I'm present for the state. My name is Mamai.
Yes, Your Honor. Good afternoon. Good afternoon. I am Kitonga for the 5th and 6th convicts. Present. So that Nomad is present with the 2nd convict. For Mr. Dasson Omari together with Ms. Vega for the 2nd convict.
Good afternoon.
Good afternoon.
Ms. Speaker, for the record, SWIGA.
First, this match is coming up for mitigation. Today, you don't seem happy.
I've been jumping from court to court. It is only the tiredness that I brought another battery.
So
Once we pick the speed, the session, you don't go that way. The one that has don't go that way. In a different matter. And therefore, he is not a first offender. That is true. He was convicted in criminal (4985) of 2009 in the Chief Magistrate's Court at Kibera. By Honorable Mrs. Nsioka, SPM Head. On the 10th of November, 2010. He appealed to the High Court, Nairobi, in criminal division, in criminal appeal number 657, 658, 659, and 660 of 2010. The learned judge, on the 29th day of April 2014, in paragraph 22, gave this decision. For the reasons set out above, we find that the appeal has merit and is allowed. The first, second, and third appellants are set at liberty forthwith unless otherwise lawfully held. It was a decision by two learned judges, Justice A. Bogoli Musaga, retired now, and Justice Lydia Jode, then now the judge of the Court of Appeal. You know, I give that decision to the court for record purposes. Excuse me. So, Your Honor, we start with the first entry that there is no previous criminal record for the first, for the second convict. Your Honor, there is no appeal by the state over his acquittal pending that will either be used against the second convict. You know, the second limb of our presentation to you is on the question the state is pushing for a death sentence. On the basis that the second accused was convicted on count 6 and 7, which carries a death sentence. Your Honor, the legislature has spoken. That once convicted, only available sentence for section 292 is a death sentence. That is section 296/2 of the Penal Code. It's death sentence. Is this the law under the current 2010 Constitution? It is our answer, it's not. The 2010 Constitution confers the court an unfettered mandate of discretion. The function of sentencing is discretion to the trial court. it is subject to very many angles to be presented before the trial. Among them is the mitigation of a convict. Which my learned sister Martina Sugar will deal with. Two is whether the courts, higher courts, have been confronted with this question, and what have the higher courts decided. You know, this question has been presented in the case of James Kariuki Wagama, James Kariuki Wagana versus the Republic, EKLR 2018. This case is quoted in the celebrated case of Francis Karioko Murwatetu and another versus the Republic, Francis Karioko Murwatetu and another versus the Republic, EKLR 2017. Your Honor, in William Okungu Kitini, versus the Republic, EKLR 2018, the courts, all the three courts in those authorities held that
Mr. Omar, you know you have an anointed voice. Your voice can go very fast.
oh,
So if you use the language,
oh, Your Honor, all the three courts held that the maximum sentence for the offense of robbery with violence is the death penalty. But that courts have discretion to impose any other penalty it deems fit and just in the circumstances. My Lord, in the case of Mutiso as a Republic, Criminal Appeal number 17 of 2008, the Court of Appeal in paragraph 34 stated, quote, the mandatory requirement of the death penalty was declared to be inhuman. Inhuman treatment or punishment, and in violation of constitutional provisions. Which are similar to ours. Come on. By not allowing for individualized consideration of the offender. And the commission of the offense. You know, in that link, we are asking you individually consider the second convict and take the circumstances specific to him. You know, the late Justice Majanja J, God rest his soul in eternal peace, in Michael Kathewa Laichena, Michael Kathewa Laichena, and another versus the Republic. You know, that's petition number 19 of 2017, EKLR 2018. The quotation is wrong. The court can be able to get it. Towards the end, it says, what is clear from these provisions is that robbery with violence is an aggravated form of robbery. With additional ingredients. Set out in section 296(2). Our major emphasis is the next statement where the learned late judge said, I would therefore take 14 years imprisonment. As the starting point for considering the sentence for robbery. You know, the learned judge, the late Muchai, has put 14 years backwards. And we shall be pleading to this court that the High Court has set a cut-off point of 14. And in the other authority, Apollo Olenja, a pizza, was a Republican. KECA 2020. The learned judge said, in that regard, we are persuaded that the death sentence imposed was not deserving, and we are entitled to interfere with that judgment of the lower court. We set aside the sentence imposed and substitute, therefore, a sentence of 20 years. Imprisonment from the date of conviction. You know, in Mohammed Hussein Mohammed, as is the Republic, KCA 2019, the court gave the parameters the trial court should consider arrive at an individualized sentence. They relied on the Muratetu matter, and these are the conditions. They must have relied. We have not quoted on that, but the court is well appraised about the Muratetu 1 and 2. The age of the offender. The system will bring about that. B, being a first offender. We conclusively confirm that he's a first offender. Whether the offender pleaded guilty, he did not, it was a full trial. D, the character and record of the offender. We'll bring that out during mitigation, Your Honor. Remorsefulness of the offender. The possibility of reform. And any other factor the court will consider relevant. You know, on the issue about remorsefulness, may it hold record that I took this matter after conviction. I wish to state that the second convict is very remorseful. Of the circumstances that happened. He seeks forgiveness from the complainant, from the prosecution, and from the court. He has learned lessons. He is appearing before you as a new creature that seeks the mercy of all the stakeholders in this matter. You're not considering the conviction. He's convicted of count 6 and count 6 and 7. Where he was found guilty of being in possession of a firearm and ammunition. He never acted in a manner that aggravated the situation. He never dehumanized the complainant. He never abducted the complainant. The state only found him with the fire. So, Your Honor, on that, his character at the time of the offense, after the time of the offense, to date, he has not behaved or conducted himself in a manner that will aggravate the occurrence of that offense. Your Honor, in Philemon Koskei Kimayo, versus the Republic, 2019, KECA, the court in paragraph 32 said, for this reason, we find it appropriate to interfere with the death sentence imposed on the appellate at the first appellate court. Proceeds, given the circumstances of the offense, and the mitigation offer by the appellant a sentence of 15 years imprisonment would be appropriate. And Stanley Kubi Songa versus the Republic, 2018 KECA. The final is that the court substituted the death sentence with a term of imprisonment for 20 years. And then Kabete versus the Republic, criminal appeal number E006 2024. E006 2024. Lady Justice D. Kabete set aside the sentence of 7 years and substituted them with sentence of 4 years and 2 years, respectively. Kabete set aside the sentence, Justice Lady Kabete set aside a sentence of 7 years in each count and substituted them with sentences of 4 years and 2 years, respectively. You know, on that lane, our final submission is that the jurisprudence coming from the upper courts frowns upon the imposition of a death sentence. And this court, being bound by the decisions of the higher courts, urge the court to be bound by that jurisprudence in favor of the second convict. You know, the last limb on the law is the question what the law is on counting the number of days a convict has been in custody. You know, the convict was put to custody on 14th of February 2015. Today marks 11 years and 1 month. We shall be seeking the court when it retires to sentence the sentence to take effect from the 14th of February 2015. And that's all on issues of law. Martina will deal with mitigation of his circumstances. Thank you.
Leniency contains, as per provisions of the law, Your Honor, and one of the fundamental principles Yes, Your Honor, one of the fundamental principles, according to the sentencing guidelines, under the laws of Kenya, include rehabilitation, restorative justice, the possibility for a convict to reform, and the possible reintegration of a convict back into the society. Your Honor, we respectfully submit on behalf of the second convict. Apologies, I will go slower. Apologies for that. We submit humbly, Your Honor, that with respect to the second convict, he has already fulfilled one of the principles under sentencing. Which is retribution, since he has been in the custody of the police for a period of 11 years and 1 month without any admittance to bail or bond terms. And even as we submit, Your Honor, we will be praying humbly that the court does take into consideration the period of his incarceration, even as the court does sentencing. And in the sentence, we pray for the most lenient terms, taking into consideration factors such as the age of the offender, and his character, Your Honor, I wish to point out that the state in its affidavit indicates vaguely as to the conduct of the second convict. And we are hopeful that the court will not consider the state's submission to the effect of paragraph 28 in their submissions, yes, Your Honor, just to reiterate that the court ought not to consider paragraph 28 owing to the fact that it has not been specified when this assertion is made to the court. It has also not been specified which of the accused persons, as they then were, uttered those words, and before which court or which trial magistrate the words were uttered to. And the circumstances of the utterances are completely unclear. Was the utterance said in unison by the first to the fourth accused person? Or was it said by one followed by the other? The circumstances are completely vague. Contrary, the second convict, in his supplementary affidavit dated the 27th of March 2026, the affidavit deposed as to his conduct, that he was a hardworking and law-abiding citizen, a family man, and the primary caregiver and breadwinner. And Your Honor, even while the second convict was incarcerated and in the police custody, he did receive his baptism. While under the custody of Kenya Prisons Catholic Chaplaincy. And he has also been an active participant in the church leadership while still being under incarceration. Your Honor, despite the fact that he was incarcerated, for the last 8 years, between the years 2015 for a period of 8 years while being incarcerated, he participated by serving voluntarily as an IT teacher, and a teacher of French language, to fellow inmates as well as prison officers. And indeed, Your Honor, there is a recommendation letter from the Kenyan Prison Services that we have attached for the court to see, dated the 18th of March 2026. Your Honor, I wish to reiterate that the second convict is sincerely remorseful and apologetic to the complainant and the state, and avers that he has undergone personal reform significantly, and rehabilitation as has been anticipated by the sentencing guidelines. Your Honor, while I close my submissions, I wish for the Honorable Court to take into consideration that the second convict also suffers from chronic gastritis. And has been receiving treatment while in custody. We believe, Your Honor, that the second convict ought to be sentenced considering the time he spent incarcerated and to the minimum sentence period owing to reasons that I have to apologize. Yes. Owing to the reasons that the sentencing guidelines have been fulfilled based on his remorsefulness, and Your Honor, we can boldly say that he is better off being reintegrated back into the society and even serving a non-custodial sentence. Since he has participated in community service and voluntary services, prior to his arrest and during his incarceration. We will wish for the court to consider the mitigating factors that we have submitted to, Your Honor, alongside the supplementary affidavit by the second convict sworn on the 27th of March 2026. Yes, Your Honor, I will conclude by submitting that we look forward to your very considerable and lenient sentence, in line with the mitigating submissions that have been made before you on behalf of the second convict.
One Regina Muchai, dated the 27th day of March 2026. Regina Muchai. She is the biological mother. Dated, the night is dated 27th day of March 2026. She's present. She's the biological mother of the accused, the convict. Then as she has sworn that she's a widow. We have filed it. We can give them a copy also. Yeah, but I expected them to talk to the mother before they write the report. But the court has it on record. And briefly, she says the accused was arrested. There is only 2 points I want to highlight. Only 2.
Okay, on record, those 2 points.
Yeah. For record, oral, the court gets it properly when it is taken orally. Thank you. You know, she says the accused, when he was arrested, had a 7-year-old child with his dear wife. The wife left and the child is in the custody of the mother. She has paid fees, maintenance, and the minor got a B+. The minor is to join university. She is 67 years old. Those facts, Your Honor, we shall be seeking the court to consider a non-custodial sentence allow the convict to take up his family responsibility over his child, and leave this old mama to manage her health condition as she ages. That's all. Thank you.
Not more than 5 minutes. The third convict. Your Honor, my instructions were limited to responding to the submissions by the prosecution. And in particular, the first one to respond to is paragraph 28 of those submissions at page 7. Your Honor, the third convict submits that he was charged as an individual. And he has been convicted as an individual. The judgment referred to his individual action of possessing a recently stolen item. Your Honor, that should be the main guideline in determining his sentence. He completely disassociates himself with the words appearing at paragraph 28 in bold. The words are, in Kiswahili, open quotes, hii kesi hatutakuja tena, semicolon. Hii kesi hatutakuja tena, semicolon. Baki huko na hiyo kesi. Baki huko na hiyo kesi na huyo Momanyi. End of quotation. My instructions are that he never uttered these words. And most importantly, they are not captured in the proceedings. Your Honor, I'm further instructed that the same paragraph erroneously casts the impression that the first, second, third, and fourth convicts were transferred from Kabete prison back to industrial area to be isolated from the then seventh accused, who was acquitted. Your Honor, my instructions are that there was a time when all murder suspects were moved from Nairobi industrial area and taken to Kabete maximum security prison. For reasons I'm not aware of. While at Kabete prison, Your Honor, this is a matter of public notoriety. 2 inmates allegedly escaped, and I believe they were found somewhere in a bush towards Kitui about 3-4 days later. I'm not conversant with their case, but from media reports, they were alleged to have been terrorist suspects, or maybe convicts, but they're associated with terrorism. That act, Your Honor, led to a shake-up in the prisons department. Including the topmost officer losing his job. And it was by that act that all murder suspects, except the 7th accused who was acquitted, were returned to industrial area. Your Honor, the 3rd convict pleads with the court to have these submissions in mind when looking at paragraph 28. Your Honor, the other issue of instructions to bring to the attention of this court is paragraph 32 of the prosecution submissions. It allegedly refers to PW20, who was given the name XY because he was a protected witness. And the paragraph alludes that PW20 was threatened that if he said anything after the offenses had been committed, he would be killed. The third accused submits, Your Honor, that everything about PW20 was oral. But most glaring, Your Honor, was that he never produced his driving license to show that he was a PSV driver. He never produced his letter of employment. The vehicle he was driving as a taxi was not produced as an exhibit, not even its logbook. Your Honor, the third convict prays that this court does not place any weight on paragraph 32 of these submissions because PW20 was not a reliable witness. In conclusion, Your Honor, the third convict pleads with this court to place great premium on his probation report. Well, on the probation report.
The sentence. The sentence?
Yes. Well, it was drawn by the probation office, I believe. Yes. To place great premium on the contents of that report while determining an appropriate sentence. That is all, Your Honor, and thank you for granting us an audience.
haitazidi bedroom 15. Niruhusu niongee kidogo na Kizungu, kidogo na Kiswahili. Nikianza na submission ya prosecution side, paragraph 2, Mr. Mumani anaeleza paragraph 2 ya kwamba accused 1 alipatikana na hatia ya kosa account number 1, account number 3 na account number 4. Naona hizi account 3 PW1 kwa jina Michael Ngatia Mtutu, account number 3 Gladys Wajira, and account number 4 Nali Mudoli Mboi. Walifanya parade pale Central National Police Station. Na parade number 1 ambayo iliongozwa na Michael Ngatia hakuchagua mshukiwa namba 1. Account number 3 ambayo ni Gladys Wajira.
Sorry. Unaelewa mahali tunafika?
Ninaelewa na reply wote mmoja anasema paragraph number 2.
Tarudi nyuma sana. Tarudi nyuma.
Kwa ufupi, nilikuwa nataka kumaanisha account 3 na account 4, account 1 na account 2 kuna shahidi alitambua accused person. Nilikuwa nataka kumaanisha hivyo. Account 4 mheshimiwa, Irene Mondoni alitambua mshukiwa kwa his physical appearance and touching.
Sorry, I don't want to keep interrupting.
Yes.
We are dealing with issues of
Sentencing.
You have made some submissions before, prior to that.
Yes.
So we don't have to go back. We come in and never met wakili. And this is like
Mheshimiwa, nilikuwa najaribu kuelezea motive ya kwamba submission ni moja imeandika, sio hivyo nimefanya kesi. Mheshimiwa Mwangi alikuja 2018 kwa hii kesi. Kama ni proceed with 19 witnesses already. Hizi submission ameandika mheshimiwa kuanzia paragraph 1 paragraph 35 sio hivyo kesi mfano. Paragraph 3 mheshimiwa inaeleza ya kwamba mshukiwa amepatikana na hatia ya kumiliki bunduki na marisasi. Naona ningependa kurejesha hii koti kwa sheria ya Firearm Act Cap 142 Law of Kenya. Key Police Standing Orders number 2B. Sitasoma yote mheshimiwa, niliona koti namba 2B. Nasema tasema tu ya mwisho. Nasema entries must be made in the occurrence book for it. Naona Mr. Mwangi hakuna mshahidi kuthibitisha kwamba mshukiwa akishikwa na bunduki na marisasi report was produced in this court, mheshimiwa. No independent witness was produced in this court, mheshimiwa. retrieve this court to go deeper and look at the law of Firearm Act of 114 law of Kenya. Your Honor, on paragraph 6, Romani anaelezea kuhusu section 296. About section 296, Mheshimiwa, I was at the High Court on 28 January 2026. Before Justice Lawrence Mugambi and the petition 036, and he delivered the judgment of that day, 036 of 2024. And he delivered the judgment, and he told that, he said that it's an unconstitutional charge, and he told the court to go and look at it. Your Honor, in paragraph 28, Omani anaeleza kuna matamshi mshukiwa alitoka kuelezea koti, amenakili na Kiswahili. Hajaeleza tarehe, hajaeleza mwezi, hajaeleza mwaka upi, hajaeleza before who, which magistrate, hajaeleza which court number. The same paragraph anaelezea mheshimiwa ya kwamba mshukiwa nambari 7 alitishiwa na mshukiwa nambari 1 mwaka 4. Since I was arrested in 15 February 2015, nilipatana with the rest of the accused person in court, And first, second, third, and fourth, and seven, we were taken to body remand prison. Tumekaa block moja, different cubes for 2.5 years. We were taken to community maximum prison on 2018. More than 168 inmates. Tulipokuwa pale mheshimiwa, tulipofika pale kamiti maximum, tuliopo block moja kwa jina G block, all of us 168 inmates. Your Honor, before I continue, I apologize because I will use maybe other languages that haitafurahisha. Akisema alitengwa akisema na kutenganishwa
haitafurahisha, mbona unataka kutumia?
nataka kutumia tu kwa record isionekane vile mmoja anasema ni hivyo. Accused 7 alitenganishwa na inmates 168 akawekwa kando block ingine. Kwa sababu pale kamiti kuna wanaume wanatamani wanaume wenzao, sasa wale inmate walikuwa wanataka kumpiga. Serikali ya pale kamiti ikachukua hatua, ikamtoa kwa wenzake, ikampatia msuri yake block ingine tofauti na ile tulikuwa tunakaa. So accused 7 hakutenganishwa na accused 1, 2, 3 and 4. na 168 inmates. Paragraph the same 28, Imani alieleza koti ya kwamba the same accused wrote an application before the court tarehe 17 mwezi wa 6 aliandika appeal tarehe 17 mwezi wa 6 2021 before Chief Magistrate Uganda ya kuomba plea kwa hii kesi. Koti ikatupilia mbali hiyo application, DPP ilitupilia mbali hiyo application akisema kesi ni kuisha inaisha, ngoja kesi ishe, ataeleza hiyo maneno anataka kueleza wakati Yona nikimalizia paragraph 32 Mr. Mwenye ameeleza kile ni 20 alitishiwa at least 1, 2, 3 and 4. Unaona huyu mshahidi alitoa ushahidi wake tarehe 20 mwezi wa 5 2019 alikuja kotini amefunikwa uso, amevalishwa kanzu, na glasses. Akitoa ushahidi wake kuna mahali ingeelezea anatambua ama alikuwa anatambua mshukiwa wa kwanza. Niliomba iko niliona ukiojiwa kwa runinga pale gerezani Paradigo, na nikasikia kuna mambo mawili ulitamka, kuna plead na kuna rebuttal. Niliomba iko review Mitigation, 11 years, 1 month in prison. Mr. Momani, on 18 March 2026, confirmed before this court that the accused person is first offender. So niliomba ikoje plead accused one and first offender. Mheshimiwa. Yayo tu mheshimiwa. Nashukuru kwa kunipatia huo muda. Uwe na siku njema.
Yes.
Naona kama unaweza itakuwa mingi, kama 6 hivi. Respond to hii Momani. Hizo addition yake reply tu kuna clear reply yake.
Okay. Kwa hiyo yako pia ukifanya bila mfanye kasaidia kwa muda mmoja.
Hata dipende wao wanaandika vizuri. Yaani tu wanaandika ile juu ile ndio kwa clear haraka. Zanza.
Kidogo tu.
Naona mimi nilikuwa tukasema sina pingamizi.
If I will just spend less than a minute. Do they not allow me to conclude? Then you come back for it? Then I have a very interesting courses tomorrow. Just spend less than 30 seconds.
Kukula zingine. Sasa hiyo tu leo.
Endelea.
Mali kesi namba 7 anasemekana alitishiwa rumani katika hii submission yake. Kiona the report of threatening at committee as state alleges the right person mwenye anafaa kuwa kuelezea shida ilipojela ni prison officer, not Momani. Your Honor, the submission of the submission of state and allege that period 20 XY was threatened by the convict, you know, on page 8, paragraph 32. Your Honor, I wonder how the state was taking this case personally. So, page 1, paragraph 2. Hayo mwenye anasema kuwa first to further case person wapatikana na hatia count 1, 2 na 3. Yote ni uongo. Your Honor, the same state in his submission, he has submitted about the behavior of the convict in prison. That the convicts are not remorseful. Your Honor, I think that the wrong information. Your Honor, the person or somebody who can explain about the behavior in prison are prison officers, not the state officer. Your Honor. As he's doing now. Your Honor, nilikuwa mbele hii koti juzi na nikaweza kupeana recommendation letter kutoka kwa officer in charge Nairobi remand, akiwa ameandika yeye mwenyewe kuwa Steve alipabu hapa na uhusiano mzuri na polisi, maafisa wa polisi na inmates wenzake, na ni leader. Alikuwa ameandika kila kitu jela iko, na ni leader, ni in charge of prisoners wengine. So the story ya Momani naona ni uongo. Your Honor. Your Honor, kila kitu state anaongelea 11 years 2 months zilizopita, long time ago. Your Honor, you cannot compare 2015 February with 2026 March. There is a big difference, 11 years. Everything has changed. Time, kurekebika,
time na kurekebika. Your Honor, even if we say someone was wrong outside there 2015, Your Honor, I beg this court, do not deal with 2015. Your Honor, I beg this court to deal with 2026. 2026, because in prison is where people are put there to reform. Which I have achieved. The rehabilitation, and I know what I didn't know when I was outside there. Nimejua mambo mingi sana yenye sikuwa najua nikiwa pale nje. Jiona kitu ya kwanza nimejua yenye sikuwa najua mambo ya Mwenyezi Mungu, sikuwa najua na sikuwa naiheshimu. Lakini ndani ya jela maombi ni kila wakati, kila saa. Your Honor, on page 8, paragraph 3, the state is talking about bad conduct in court. Your Honor, there is nowhere the accused has shown bad behavior in court. Or there's nothing more money the state council has put before the court to show the bad behavior of the fourth accused convict. Anything to show I'm bad. Only word of mouth. Your Honor, mimi mwenyewe nimethibitishia koti kuwa I don't regret kuwa jela, cause nimelearn a lot of things zenye singelearn kama singeingia pale. Nimejua kuchoose friends, nimejua crime si poa. Nimejua crime si poa. Your Honor, nimesikia pia state kwa submission zake ameconsider sana society huko nje na public interest. Your Honor, kuna senior counsel Dr. Kaminwa alikuja kotini na akasurprise koti yote. I surprise state, judge, na kila mtu alikuwa kotini wa kusema kuwa this is the time to give these young boys and girls freedom to go home. These are not the people who committed these offenses. Your Honor, to go before your brother, retired your brother Bononga, Justice Bononga. Justice Bononga. Na baada ya hayo matamshi ya Dr. Haminwa yenye itoka kwa familia ya kutuwasema tuachiliwe hata kama ni kwa free bond, State alipinga. State alipinga, akaleta kitu cha character assassination union. Na Bononga, Justice Bononga, Justice Bononga, direct speech alisema character assassination haikubaliki mbele ya koti. Ile kitu inakubalika ni ile kitu kwa koti kwa hiyo wakati, lakini kuanza kusema mtu ni mbaya kama mtu ni nani, ilikuwa ifuatiliwa maanani. Na hapo after kunyima bond for 10 years, Justice Bononga alikuja grand bond. Kwa hiyo matamshi ya Dr. Hamini wa kusema sio hawa waachiliwe, tuweza kuwa bond yote. Yona Dr. Haminwa ni wakili wa the deceased, the late MP George Muchai na familia yote. Alikuja kotini akasema yeye kama rafiki, kama ndugu, kama mteja, kama client wa mheshimiwa na kama wakili wa familia, amekuja kotini kwa niaba ya familia kusema accused person waachiliwe. Tunaona tuliachiliwa shingo upande, tulikuwa bond, tungeweza pleas sababu local pia kutupatia. Sasa tulikuwa tuko ndani ya jela yote, lakini high court iweza kutugrant baada ya Hamini kuongea maneno yake. Your Honor, since this matter started, there is no any witness who has come to this court to complain about being threatened by somebody or someone, ama kuweka affidavit kotini ya kusema ametishiwa. So what Omani is bringing right now, tayari ametushika, lakini anakushika zaidi. Anaongeza vitu zenye hazijasemekana kwa kesi, ndio tuonekane wabaya zaidi. This is a storytelling by state. No any record to prove the same in the proceedings of this case. Your Honor, still on that state battle, Your Honor, the state has bad intention, and I think he has put this case as a personal. Because if you see on page 7, paragraph 28, he has talked about the character of the accused person. Your Honor, if the state Momani is talking about the character of convict that the court has deal with issues of indiscipline, anasema kuwa koti imepia tuhukumu kwa discipline, tumekuwa discipline mbaya na koti imetuchukulia hatua. Sijui ni hatua gani tumechukuliwa, kwa sababu inasemekana koti ilichukua hatua. Sijui kama ni kufungwa tulifungwa ama tulifanywa namna gani, lakini anasema koti ilichukua hatua. Na hakuna hatua ishachukuliwa mbele ya mahakama kwa nidhamu kwa pande yetu. Tumekuwa tukibehave vile inafaa kotini. Your Honor, the correct position is nowhere the court have punished the accused even a single day for misbehaving in a state unalleged. The only things the state is talking about is what he think or what he want, not the proof. Your Honor, page 1, the state confirmed that the court delivered his judgment on 13 March 2026, and all the 4 convicts, they have been caught by the 3 count of robbery with violence. Section 290, robbery section 296(2) of the Penal Code.
I will just give a 30 seconds as we can. It's okay. It's okay. Could we have the second? Okay, please, spell out as
Now we are working from the 4th to the 6th.
yes, sir. And I believe Member President Omani will be on it to reply.
Your Honor, tarehe 4 tunaenda kubook, tunaongelea maneno private. Neno nzimo kwa wale man in the book